Welcome. Greetings, deception stoppers, guys. You see where we at? We're out at our favorite place, or one of our favorite places. And I'm gonna, so welcome, new subscribers. As usual, we want to welcome the new subscribers to the channel. We've been busy. We've just been grinding as usual. But today, we got something special to talk about. So get relaxed, get your popcorn and whatever you need. This is about to be serious.
Okay, today we're going to be talking about what's been going on in the federal case in the District of Arizona. As you all know, we have a RICO case in the District of Arizona, and it was filed May 8th, 2019, a few months ago. And we got a ruling on the 83rd day, okay? So it's been 83 days. The ruling came in August 1st. And as you all know, that there were about 30 defendants on the complaint, 30 defendants, and 25 John Doe defendants. And of all those defendants, they all were properly served, and they all responded accordingly to the complaint, and they responded via motions to dismiss, and many of those motions were brought pursuant to lack of personal jurisdiction, and I think one from the state attorney general was failure to state a claim upon which relief can be granted. Now I'm going to get right into this, and I'm going to get into this as easy as I can, so that everyone could try to understand what it is that I'm saying. So I'm going to be breaking certain things down. I'm going to be breaking.
Why you say it like that?
I'm going to be breaking things down so that way, the people who might not listen to legal videos every day, they could still follow along and interpret what I'm trying to say. Okay, getting right into it. The first thing that I want to talk about is federal courts. Okay, now a lot of people may know that federal courts, they can enforce state law sometimes, and they primarily enforce federal law. When they enforce state law, then that is because the defendant, in most cases, reside in another state. For example, if you're suing somebody and you live in Colorado, but the person that you're suing violated a state law, and you want to sue them and they live in New York, then you have to go to federal court in order to do that. All right, and when you go to federal court to do that, it has to meet certain criteria. One of those criteria is you have to have been damaged at least $75,000, and another criteria is that they have to live in another state. So if you live in Colorado and they live in New York, and they damaged you for $75,000 or more, then that's what the district courts regard as diversity of citizenship jurisdiction. So the jurisdiction is based off of diversity of citizenship. That's the nickname for it. Okay, did everybody follow that beautifully? Okay, moving right along. Now, when you file a federal lawsuit under diversity of jurisdiction, oftentimes the federal court is mandated to use the state court's long arm statute. Okay, now what a long arm statute is, it's a statute that allows the state courts, which are courts of general jurisdiction, and it allows the federal court to be able to reach their hands from out of their state over into a state and grab that defendant and say, bring your ass over here for violating that law. All right, so it basically brings them over here for violating the law. Now, there's various different criteria that have to meet in order for that state's long arm statute to be utilized. There have to be beautiful.
I know. I was looking at your. I watched more of your videos.
You watched one of my videos?
Good talking to you.
Did you see the one that you was on there?
You know what's funny is I said I know I'm going to see myself on one of these because a lot of them you're at Red Lobster, and then I'm like, I know you're always videoing here. I probably am. I told Lisa she's probably on them too.
Okay, so the state's long arm statute, again, it allows you to reach outside of the state and pull in the defendant. Now, the defendant must have minimum contacts. The defendant must have had minimum contacts with the state where the federal court sits at, okay? If they haven't had minimum contact, which means they had to have either been in that state or they had to have caused damage that was directed to that state, all right? If they caused damage that was directed to that state, then and they were never in that state, then they can also be brought in. So that would meet the criteria, okay? Now, we're gonna shift and stop talking about diversity of citizenship jurisdiction for 1 second. Now we're gonna talk about something that's called federal question jurisdiction. Federal question jurisdiction operates totally different, all right? And many of the defendants in our case, they didn't know that. Okay, I'm gonna get to that in a minute, but I want you guys to know how the difference between these two jurisdictions before I start talking about these attorneys. Now, these different jurisdictions is diversity of citizenship jurisdiction. Now the other one is called federal question jurisdiction. Now that is the jurisdiction that the federal courts primarily operate under, all right? Primarily because they're enforcing federal laws, all right? Federal laws enacted by Congress in the United States, okay? So, understanding that, when you bring somebody into a federal court for federal question jurisdiction, that means they violated federal law, all right? That means they violated federal law. In order for there to be jurisdiction based on federal question, federal law have to have been violated, all right? That means they violated the Constitution or one of the articles of the Constitution. One of the articles, or they violated one of the clauses or one of the federal laws, all right? Those are the different ways that they can get pulled in under federal question. And there does not have to be $75,000 worth of damage, okay? Okay, so we clear on that. All right. Now, when you assert federal question jurisdiction and you bring somebody in on federal question jurisdiction, it doesn't matter where they live. It doesn't matter.
They can be down in Hawaii.
They can be in Hawaii, and you can be in Maine. And if they violated that Constitution, if they violated your federal rights in any way, shape, or form, they can be brought in. They don't need to use a long arm statute to reach, because guess what? Federal question jurisdiction is limited by national borders, okay? Not state borders, okay? Again, I'm gonna say it again for all those attorneys who turned in these raggedy motions that they turned in. Federal question jurisdiction does not require a state's long arm statute because it does not involve a state law claim, okay? Now let's get right into, back to the case. So now that y'all understand federal question jurisdiction, and now that I've explained diversity of citizenship jurisdiction, now we're going to talk about the case. So I gave you guys a little bit of knowledge on the two different jurisdictions so that you understand what I'm about to talk about. All right. First of all, we had all these attorneys, they turned in motions to dismiss, and those motions, all of those motions were premised, were brought pursuant to lack of personal jurisdiction, meaning that They were saying, oh, that federal court way over there in Arizona doesn't have jurisdiction. They can't pull us in over there. We've never even been to Arizona. We've never vacationed. We had once, we had Catherine White's attorney. She said Catherine White was only in Arizona 15 years ago. And I mean, these people, I mean, I was so embarrassed for them. I was so embarrassed. You had the state attorney general of Ohio. They turned in a motion talking about the court didn't have jurisdiction.
They had to know that stuff.
Yeah, and these is people working in the state attorney general, and they don't even know that.
They need to know that stuff, man. That's crazy.
I was so embarrassed, and I completed all of these motions. I completed a response. You know, we provided a response to all of their motions, and I was embarrassed for those people as we responded to their motions because it was totally embarrassing. I was thinking, did these people even go to school? Did they go to school?
I don't know what they did. They weren't paying. They just got.
Oh, it was so embarrassing. And then let me see who else. We had another attorney. Her name was Mary Beth Mellett with the Buckeye Ranch. She said in her motion, she said, the court doesn't have jurisdiction because the U.S. Marshal didn't deliver the complaint. I was like, are you serious? Are you serious? Come on now. Come on, Mary. That was ridiculous.
Pathetic,
yeah, that was pathetic. And then we had, okay, let me think of some more.
Did she say something else crazy? She was like,
oh yeah, she said, cause she know that we made some pretty outstanding arguments, and you know there was nothing to say. When you have the truth on your side and you put that in the form of a legal argument, there's nothing to say back. So she said, well, I don't care if it was conspiracy or not, because we said, you know, it's a RICO conspiracy, and she said conspiracy or not.
that's crazy.
The court doesn't have personal jurisdiction over my
She was
client.
emotional when she
Conspiracy or not, yeah, she was very emotional. That was very
beat up.
That was very unprofessional.
I guess I'll be emotional too if I know I went to school, went to you know, grad this schools that practice law, spend all this money, thousands of dollars, I'm in debt, and then if somebody off the street comes in the picture and start my
and rock your gut.
Rock my gut.
Those guts got rocked.
I'll be emotional too. Someone came off the street and in the picture they brought me up like that. And with no credentials as far as going to some law school or whatever. That's embarrassing, man. Like that goes to show you right there how valuable time is.
Yes.
When you got time and you got your own mind and you are in a natural state, that's powerful. But when you you know what? Go ahead.
So getting back to it. You know, so that was just various motions that was turned in. They was telling the judge, oh, the court doesn't have personal jurisdiction. We want our legal fees. You know, we wanted you to issue an order and make them responsible for our legal fees because they filed a lawsuit in Arizona. First of all, we live in Arizona. We're domiciled in Arizona, so we have a right to file a federal lawsuit where we are domiciled. Okay, we have a right to do that. Okay, so that's what we did. So they were kind of ticked off about that. They were pissed off about that. Thank you so much.
You're welcome.
Thank you.
You're welcome.
They were pissed off about that because they felt like we were just trying to create a burden for them, and you know we weren't. We were not trying to create a burden for them. We were really being wholeheartedly honest, you know, just, you know, getting our First Amendment redress for grievances, you know, in the District of Arizona. Now, you know, this lawsuit was primarily filed under RICO law, and they needed to get some type of help, you know what I mean, because they got mopped up pretty bad in the motion play. So it was about, I want to say it was about 23 or 24 total motions like that, because many of these defendants are represented by, you have, for example, Amy Hires. She represents 7 defendants. Okay, so in Amy Hires' motion to dismiss, she said the court lacked personal jurisdiction, and she just went on rambling and rambling and rambling.
She was pretty much, wasn't she like just saying what you just said in the complaint?
She was repeating everything in the complaint just to fill up the paper. Yeah, she was filling up her paper. And it was really embarrassing. I was completely appalled because she made no adequate arguments as it related to the defense that she asserted for her clients as far as lack of personal jurisdiction, because the District of Arizona had personal jurisdiction over all of them, okay? And they argued that since it's 30 of them and only 2 of us, then we should be forced to go to Ohio to adjudicate the case. So what had happened was the judge in Arizona, our judge is federal judge Diane J. Humatewa, and she is was the presiding judge over the case. Now, she made the ruling August 1st, and she said in her order, she said, you know what? I'm not going to address any of those motions. She didn't address any of those motions because she didn't want to embarrass them. She didn't want to embarrass them because they were just asking her to grant their motions, and because the court didn't have personal jurisdiction, okay? She could not grant them their motions and tell them that the court did not have personal jurisdiction, because the court did. The court did. The court had personal jurisdiction.
And she didn't say nothing. She didn't say nothing about that.
She didn't say nothing about that in her order, that the court lacked personal jurisdiction. She said, you know what? I'm not getting involved in this. I don't want to touch it. So she said, I'm going to transfer this case to Ohio, to the Southern District, and let them deal with it. I don't want to touch this.
And that goes back. That takes us back to that statement that guy made. Where were we at that time? Where did we go?
We went to the state attorney general, the state of Ohio attorney general, and the man in there, he said, nobody's going to want to touch that. That's deep. And so now we understand why he did that. And so Judge Humatewa, she didn't want to touch it. She said, you know what? I'm transferring this out. So she transferred it. She didn't make no rulings on none of the motions. And she actually
didn't address RICO or nothing. She
didn't address RICO law, and she just said that the lawsuit shouldn't have been filed in the district under 28 USC 1391, but she was wrong. And in my opinion, and this is a disclaimer, in my opinion, they made her do that. Because the order, it didn't make sense. We had our constitutional rights invoked, none waived. So she was up against the wall, and she probably didn't want to violate her oath of office. So she said, you know what? I don't want to get involved in this. I'm transferring it. So what ended up happening was on August 1st, she issued an order and transferred the case to the District of Columbus.
Got these put on a separate plate so you can keep the sauce, okay?
Ooh.
Thank you so much.
We didn't even expect you to be here today.
You didn't expect what?
We didn't expect you to be
We
here.
came one time.
I'm here all the time on Mondays on double.
Oh, one of them days we came.
Today is Monday. Yeah, I keep
I
forgetting.
still work Sunday, Monday, Tuesday, doubles, 12 hours. Love every minute.
Well, we love having you.
I'm just kidding. All right, guys, enjoy, okay?
All right, thank you. So, what was I? So,
About the she said that this court shouldn't have been this.
yeah, she said under 28 USC 1391. So basically, she addressed that we filed our complaint pursuant to the venue and pursuant to the venue under 28 under venue code 28 USC 1391. But she didn't say nothing about the venue code 18 USC 1965B of the RICO, the provision under 18 USC 1964C. All right. So what she did was she ignored that part. So we said, you know what? My heart go out to her. I see what position Judge Human Taywall was in.
It's a pattern because we 2,000 miles away from Ohio. How is it that we're like 2,000 miles away from Ohio, and she's doing pretty much the same thing that they did back in Ohio. Only thing that's different is, and I give her respect for this. I understand her position. She didn't really violate her. She didn't violate her oath of office, and she stayed safe. And said, I don't want to deal with it. I'm gonna just transfer it. I'm not gonna address nothing because the whole complaint is correct. They got 8 alive. They got 8 up. They didn't get their motions granted. They looked like a bunch of amateurs filing paperwork.
And didn't get their attorney fees or none of that. So subsequently, what ended up happening was after the order went out August 1st, they transferred the case immediately because the order was issued actually July 31st, but it didn't hit the docket until Friday the 1st. You see what I mean?
Good?
Yep. And so when it hit the docket, what ended up happening was they transferred the case to Ohio. So we logged into Pacer and we was like, okay, let's go, let's see, what they doing over here in Ohio. Let's see who got it. And lo and behold, they sent it. They got judge. They got magistrate.
Preston?
No.
Devers on there?
Devers. They got Magistrate Elizabeth Preston Devers on there again. Okay. And I was like, this is. They're supposed to be randomly selecting these magistrates, okay? And then you don't even have to have a magistrate on your federal case. You can opt for Article 3 constitutional judge, and that's it, okay? So you don't have to have a magistrate because a magistrate can only make recommendations in law, okay? Magistrates can't issue court orders. So we're not going to be dealing with a magistrate. We don't care if they assigned a new one there or not. We're not going to be dealing with one. So basically, they transferred the case over there. We checked it this morning, and come to find out, Elizabeth Preston Devers recused herself, which she should have rightfully did. She should have recused herself because she didn't have no business being on that case because she ruled on the case against Judge Kim Elena Brown. Now,
she ruled on it or
I mean, Graham ruled on it, but she was a component of that case, so she can't be impartial, so she had to recuse herself. So she had to get the hell out of there because she know we was gonna come with that motion and get her ass out of there if she didn't get her ass out of there on her own accord. Okay, so what ended up happening next was we went on ahead and we said, you know what? We're not about to play with these people. We mean what we said, like we said in the last video. We have to go to the 9th Circuit and we have to go to the Supreme Court. Then we're going to go to the Supreme Court. We're going to do everything we need to do. And so we went on ahead and we went down to the district court, the federal district court downtown here in Arizona. And we appealed that. We said, you know what? We read her order and, me and Moses, we had a chance to sit down and we picked it apart a little bit, and it was we were upset. We were upset because they're not playing fair. Okay. Now, if those motions, if our replies to their motions would have been wrong, then they would have granted those motions to them, and then they would have cited us for them legal fees.
Exactly.
But since we had it right and they had it wrong, They said, oh, well, there's no way I could rule on these motions, so I'm just going to transfer it. And when they transfer that case, it moots out. All of those motions are now moot. All of those motions are now moot, meaning that all the money that their clients paid them to put those motions together is wasted money, because now those motions are irrelevant. Okay, those motions are irrelevant because they're not going to cite lack of personal jurisdiction in the federal courts in the Southern District of Ohio, because they put in their motions that it can be heard in the Southern District of Ohio. So what the judge out here did was, she saved them the embarrassment of getting their motions to dismiss denied. She saved them the embarrassment. So, but yeah, they got their asses kicked. They got their asses kicked. So, what else? What else it was?
I mean, it just, we were just going to give like some, although she did that, like I said, I understand. We not mad at her because we understand her position. She didn't want to violate her oath of office, so we not really upset with her.
Exactly.
Because it's a pattern, and we like the fact that our case was moving.
Exactly, and she have people that she has to answer to. Okay. She has people she have to answer to, so
this just bad because these people, deep state or the hidden hand or whatever you want to call them, these people in the background, they just expose themselves by doing that. Like, if they would have wrapped this up a long time ago, I mean, I don't know, who knows? Maybe we would have learned about them later on. That much information, we wouldn't have even had a thought of those people existing like that. Because now it makes sense for why all this happened. We've gotten, like he said before, we've got to the bottom of this
all the way
whole
to
thing.
the bottom of it.
We understand where this came from and how this all started. It's deeper than just my wife did this. It's deeper than her. She was taking orders, as far as we concerned. You know what I'm saying?
Exactly.
So it's pretty. It's pretty sad that they pretty much compromised their whole operation. It ain't no conspiracy theory. Any smart person will be able to sit down and look at this whole thing and say, wait a minute, how did that happen?
Yeah, it stinks to high heaven. It really does. So getting back to the case, we went down to the federal district court and we appealed her order. We appealed her order to the Ninth Circuit. Okay, so we put the appeal in today. They are probably getting the notification tonight that the appeal went in. That's probably it right there. And so now they won't be able to move on the case in Ohio, the case that transferred to Ohio. They won't be able to do nothing in that court until this appeal with this Ninth Circuit is over.
And that's gonna take probably a year, 9 months to a year or something like that.
Yeah. So it's not like we said. We expect to be in this for a few more years. We expected we taking the worst case scenario on everything, right? And we had a feeling that would happen. So they got their little help. So we're gonna do what we have to do and move forward and move along. So now it's in the Ninth Circuit's hands. And so now all of those defendants have to pay their attorneys to submit briefs to the Ninth Circuit. And to grandmother's house we go. Okay? So, they thought we was just going to go away and that this thing was going to be wrapped up. No, you don't get away that easy. We exhausted all the remedies.
Why not? Information is there. We got the knowledge. You ain't got to do no attorney being abused. Why not? This is practice. This is all practice. This is all training. This is all like learning. This is all EXPs, as I like to call it. It's all EXPs. It's prepping for the future things that's gonna happen like this. This is important.
And let me talk about something else. Let's change gears and let's talk about immunity. Now, Maureen O'Connor, which is the Chief Justice of the Ohio Supreme Court, in her motion, she they stated, oh well, they tried to be slick. They tried to fast talk the courts down here. They tried to say, well, we get judicial immunity. We get judicial immunity, and the Ohio Supreme Court get judicial immunity, and Maureen O'Connor get judicial immunity. No, no, the fuck she don't. No, the fuck they don't, because Maureen O'Connor was not sued for money damages. She was sued under Ex parte versus Young, which is a doctrine that allows you to get an injunction to stop someone from doing unconstitutional activity. And in the event that you require an expert or an attorney to assist you with securing that, then they are liable for those attorney fees and expert fees. Okay? In the state of Ohio, they the state of Ohio, they were not sued for money damages. You know what I'm saying? They were sued under Ex parte versus Young. So there was no immunity that could be asserted against Ex parte versus Young. And the 10th District Court of Appeals and the 9th District Court of Appeals in Ohio, they have become commonplace for violating constitutional rights. And you see what I mean? Especially in our regards, they did it like in 3 or 4 different instances as it relates to us. So they established a pattern amongst the claims that we had in their hands. So because they established a pattern amongst the claims that we had in their hands, then that constituted a pattern, which constituted a custom that was adopted, and that their final policy enforcers gave the approval of, and they ratified that. So they violated the Monell, the doctrine of Monell. Okay? So that's a Monell claim that they violated that got secured against them. Now that Monell claim is very strong, and you cannot assert no immunity against no Monell claim when those criteria is met. Okay? And they tried to do that, and they were totally erroneous. So they pretty much embarrassed themselves, and they wasted their money. And it's going to be interesting to see what's going to happen when we do get into the district court eventually, when this appeal is over with, whether it be this Arizona district court or whether it be the district court in the Southern District of Ohio, because we're going to rock their world, because they don't know what they're doing. They didn't know what they were doing. They did not know what they were doing, because like we said, when they're going up against other attorneys, they don't have to do any work, because they don't have to do any work. They get on the telephone and they already know what's what. Okay, so this is a different ball game. So they
Ring rush.
Yeah, they have ring rust, and we know that they watch these videos. We're not stupid, so we don't need you guys or anybody else to come in the comment section and say, "Oh, they're watching these videos." No shit, Sherlock. So it was good that they wrapped it up though in Arizona, that they wrapped it up in 83 days.
Yeah, that was good. It was moving. We weren't getting no movement like that in Ohio. They was like totally abusive up there. But again, they slept on us. They didn't know what they was dealing with. And then by this time, I'm pretty sure since all this time that went by, they know who they fully know who they dealing with. They ain't dealing with no damn fools over here.
So not Amy Corrigal Jones, she got additional attorneys this morning. So she got 3 attorneys that represent her that signed on, and 2 additional ones that signed on down in Columbus. Yeah, Amy Corrigal Jones, she violated the 14th Amendment in the United States Constitution in an atrocious manner. It was atrocious with her and Mr. William D. Wellemeyer, a.k.a. Bill Wellemeyer did, in the wrongful death case that we had going in there. So it's really appalling what they did, and we consider Amy Corrigal Jones and Mr. Bill Wellemeyer we consider them as judicial criminals.
Domestic terrorists.
Yeah.
That's what they all are.
Mm-hmm.
I mean, I don't care if you were taking orders.
Yeah, you can't.
You accomplice. You're like, you accomplice. You're like, you involved. You have any. You are part of any type of criminal activity. You accomplice. That's what it is.
And what they did is, what they tried to do is, Amy Corgall Jones' counsel tried to argue that she gets judicial immunity. If they tried to argue that she gets judicial immunity, she don't get no goddamn judicial immunity. Okay? Because her acts were non-judicial and they're not acts that's normally performed by a judge. Okay? If you have a wrongful death lawsuit that's going on for 2 years, you're not keeping the plaintiff out of court the whole entire time. I never even had a chance to meet this judge. I never seen her. Okay? I never seen her. So how are we within the parameters of the due process clause, substantive due process and procedural due process? How are we within the realms of those due processes if we are not allowed in the court to make a record, an in-person record? We weren't incarcerated at the time that the proceeding was going on, so there was no good cause shown as to why we were kept out of the courts. That's fraud. That's an extrinsic fraud, which vitiates all of the rulings that was made in that court.
What's that other thing? There's another name for it.
Fraud upon the court.
Not fraud upon the court. It was the they trying to make it seem like that process is legit. They going through.
Oh, honest services fraud.
Yeah.
They violated the RICO law, and
they kept it on there.
And yeah.
Is your tasting wonderful?
Yeah.
Okay, good. I was like, oh, they're talking to somebody. Thank you, honey.
Thank you so much. And they used the telephone to they changed the in-person conference in the court to a telephone only. Okay, to keep us out of the court because they was told to do that, and we have everything that we need to support that. Okay.
Scared to go into it. How ironic! You got these courts set up, and you're scared to go in there and battle. You scared to go head? No, you scared to go head up.
Yeah, they don't want to go head up. It's just like somebody trying to jump somebody. Y'all want to fight when you think you're gonna jump somebody and shred them to smithereens. But when they start fighting back and they start tapping that ass, then you don't want to fight no more. Okay? These people, I can't believe they put these motions to dismiss in. They should have just waived that and should have got right to the matter because the case is not going away. Mm-hmm. The merits of the case is not going away. It's not going nowhere.
Then they have some attorneys asking for her to dismiss it with prejudice or something like that.
Yeah, you can't ask her to dismiss the case with prejudice. How you gonna ask the judge to dismiss the case with prejudice?
Because they already knew what was gonna happen.
And those is valid claims in there, supported by affidavits and corroborating exhibits. These people don't know what they doing. They need to switch their attorneys.
They need to retire. That's what they need to do. Find another field to practice in, because that's embarrassing. You know what? If I was an attorney and I'm going up with somebody who gets that like that.
Good.
Oh yeah.
If I was an attorney going up against somebody like that, and they wipe the floor with me like that, I couldn't go to sleep at night. Cause it's like I went to school for this.
Yeah, you were an actor at that point. You're an actor. Yep. And they got all these extensions, filing late shit. Their pleadings was late. They asking the court for all these extensions. Okay.
Backdating certificate of service.
Backdating the certificate of service, Todd Sidoti, and not providing replies. Not providing responses to my reply to their motions to dismiss. It was raggedy. The whole thing was just raggedy and embarrassing. Okay, you could tell they were not properly prepared. They were not properly prepared. But we're not gonna make this video too much longer. We're going into 40 minutes, and we do want to say all constitutional rights invoked, none waived. And I still got a plate full of food, and I'm about to eat every last bit of it. But we just want our viewers to know that the case is now in the 9th Circuit. They tried to push it to the district court in Ohio really quickly. But not so fast. We still got to go to the Ninth Circuit and to the Supreme Court, and then we gonna rock and roll. Okay. So, yeah, all constitutional rights invoked, none waived for this video, and we will be giving periodic updates, and we'll be talking about more stuff to educate people on certain things within these laws and certain things within these type of situations as we wait to see what the circuit court is going to do and things like that. So yeah, their motions were I was appalled. I mean, I'm going to be completely honest with you. I was completely, overwhelmingly appalled by their motions. But if you have any questions about anything, enter it in the comment section. And always remember, never give up. Fight, 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 fight. Okay? We will not stop fighting until we are made whole again, until there's a remedy provided. No matter what happens, the fight is going to continue until the right thing is done. All right? So, with that being said,
Yeah, because we already know, we already know that at this point, having gone through all this and seen all this stuff, we already know ain't nobody going to jail, ain't nobody getting fired, ain't nobody going to prison.
because they were all taking orders.
Yeah. So
it is what it is, and it ain't what it ain't. So with that being said, let's make a toast and cheers. And we out of here. Au revoir.
peace out.